Good afternoon, everybody. Welcome to WG University, Weber Gallagher's series on educational programs. This is our workers' compensation webinar series. I am John Kuttner, and I'm presenting today with Jeff Lockyer and Lucas Shovelak from our Philadelphia office. Each month, we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage risk in your business. If you'd like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, wglaw.com, and you will find copies of this presentation and others under our WG University page. Also, feel free to contact the firm with any questions at this email. Today's presentation is the Opioid Epidemic, Managing Opiate-Related Workers' Compensation Treatment in Delaware, New Jersey, and Pennsylvania. Next month, our topic will be Course and Scope of Employment. Is the coming and going rule still a viable defense in Delaware? So let's get started. So as I said, we're going to be talking about opiates in each of our states here today. And we're going to start out with a little bit of history regarding opiate-related drugs in the country and where we started with this. And it might surprise some of you. Trying to flip a slide here. So, heroin was mass manufactured by the Bayer Corporation back in the 1890s. The same company that manufactures Aleve, aspirin, Alka-Seltzer that you find in your drugstore. In a pattern that's later to be repeated, which is currently what's going on in the current opioid crisis, doctors began noticing a surge in addiction, which eventually led to legislation in the 1920s outlawing heroin as a drug.
Bringing us a little bit more current, we have Oxycontin, as I'm sure you're familiar with, first appeared on the scene 1995, at that point as a treatment for end-stage cancer patients as opposed to the more prevalent uses that we see today. Pressure from government agencies, drug companies, medical organizations, and patient advocacy groups, however, led to a surge in prescriptions. Initially, Oxycontin was believed to be a non-addictive pain medication, which is a surprise considering where we're at today. In 2012, 259 million prescriptions were written, nearly one bottle for every American. So that's really something to consider, especially because not every American's on these drugs, just to see the volume that some individuals may have. In some states, prescriptions outnumber the total population of the state itself.
So that leads us to where we are now, which is the current state of crisis in the country. So nationwide overdoses on opioids are the leading cause of death for Americans under 50, and that's pretty staggering statistic. Last year there were 64,000 fatalities, which is more than motor vehicle accidents, gun deaths, or the Vietnam War. And deaths involving synthetic opioids have rocketed up 540%. I'm sure most people have heard some of the issues with fentanyl and some of the other synthetic opiates that are prevalent now and more dangerous in many ways than even Oxycontin. Part of the issue with how we got to where we are with Oxycontin is it is a slow release form of opiate. So that means that throughout the day, it is dispersing opiates throughout your body, as opposed to something like a Percocet that you take, it's short acting and it wears off. So that has had an impact of really hooking people on it.
And what this has all resulted in is higher costs for carriers, employers, in treating patients. Costs incurred for opiate use often goes far beyond the cost of the prescription drug. In 2012, Lockton Companies reported a report concluded prescription opiates are the #1 cost driver, controlling the ultimate cost of indemnity losses in workers' comp. In 2013, there was a study that showed costs related to opioid abuse, which includes wages, healthcare, treatment, total about $78.5 billion. And a Hopkins accident research study found in 2012 that injured employees who were prescribed even one opioid had an average total claims cost 4 to 8 times greater than employees with similar claims who had not been given opioids.
So just to delve into some of the costs that are attributable to the increase that we've seen, increased emergency room visits. You can think of all the overdoses that we're hearing of, obviously result in emergency room visits, as well as just drug-seeking behavior. The increased number of people going to emergency rooms is seeking opioids. We have factors involving death, which is an obvious thing that we know now from the staggering statistics that we have in Pennsylvania, Delaware, New Jersey, and other states throughout the country, and just how this is really a national epidemic. We have addiction treatment, which I'm sure some of you as carriers have incurred as a means to try to cut back on opioids. It's very costly, especially inpatient treatments that can go over a duration of time with maybe multiple attempts in order to achieve what you're really after and pushing the individual off the opioids. And then just other related illnesses as well. If you think of the list of all the complications you might hear with any medication, that when you're watching a commercial, for example, the long list that you see at the end, you could think of all the related illnesses just from opioids alone that are causing additional treatment costs outside of the drug itself.
Right. So when we talk about costs, you're also talking about two of the main issues that have kind of driven this crisis by most accounts. So one is that there's a tremendous financial motivation behind all of this for the companies manufacturing the drugs, dispensing the drugs, and prescribing the drugs. So what you're seeing here is physician dispensing has led to markups of anywhere from 60 to 300%. That's obviously a multi-billion-dollar industry in general, but that in some sense is driving some physicians to prescribe medications because it's profitable. You also have another issue of, do physicians necessarily understand when they should be prescribing it? Pain management physicians will tell you that they're the only ones that are specialized enough to know how to use these drugs properly. So you have a family doctor that's prescribing opiates for something maybe they don't need to, or maybe it's too much. And what ends up happening is you have an average of 3 times the quantity that should be provided to an individual when you have a physician dispensing the drug.
And just currently, the federal response to the crisis. Last year, the new administration appointed former governor of New Jersey, Chris Christie, to lead the President's Commission on Combating Drug Addiction and the Opioid Crisis. Governor Christie in New Jersey has taken that upon himself in the last year of his administration to really take this issue on head on in New Jersey. One of the main recommendations out of the federal government is so that the prescription drug monitoring programs, which we're all going to talk about a little bit, or PDMP, becomes interoperable between all of the states. And what the monitoring program allows is for doctors to view a patient's history and determine if they've been getting drugs from other doctors. And the federal government is trying to make this so that we can view state to state. So with that, we're going to jump into the states, and I'll start with New Jersey. So just some quick stats in New Jersey. In 2016, there were 10,308 naloxone shots administered, while so far in 2018, there have been 2,151. Naloxone is a drug that they administer to people who have overdosed. The cops have it, EMS. So that's a lot so far this year. 2014, we had 1,300 deaths from overdoses, while so far in 2018, there's been already 708 overdose deaths just in 3 months. So clearly on target to exceed double that, which is fairly staggering. 2017, there were almost 5 million opioid prescriptions written in the state of New Jersey alone. I got all this information off of the New Jersey Cares website. They created this website last year. You can go on it, and it gives you up-to-date stats. This is where I took this from. It's pretty sobering information. So in New Jersey, if you're a comp carrier or your employer, the issue becomes, how do we address the issue of rising costs and patients who are on opiates or seeking opiates in workers' comp? Well, the first tool we have to really address this in New Jersey comp is the right to control treatment. If you practice in New Jersey, if you're an adjuster in New Jersey, you're aware of this. We get to direct where treatment starts and we get to pick the doctors. So the best thing we can do is determine who is going to be on our panel of doctors and who we're going to send an injured worker to at the inception of a case. Knowing the doctors is key. So you need good counsel to advise you on that if you don't know yourself, because from the very beginning you want to send them, whether it's a significant injury or a fairly minor injury, you want to make sure you're sending injured workers to good doctors, because you may pay more on the front end, but you're going to save money on the back end if you have good treatment. They're going to get back to work quicker, and they're hopefully going to avoid the need for ongoing pain management. In the event that you do have a doctor refer someone for to a pain management doctor, which we never really like to hear in New Jersey, because as soon as you hear that, you figure you're going to be sending the person to pain management indefinitely. That said, there are good pain management doctors in New Jersey, and there are bad pain management doctors in New Jersey. So you need to know who the conservative doctors are. So really, right to control treatment in New Jersey is key to trying to nip this in the bud from the beginning. The second thing we have, as I discussed a little bit before, is the drug monitoring program. That's key. Doctors, as soon as somebody goes to the doctor for an injury, they get to determine whether or not this person has been to other doctors getting drugs, opiates, etc. So that's really been helpful. Before this, you were in the dark about what their history was with regard to other physicians, really. And the last thing I'm going to touch on for New Jersey is legislation that was passed early last year in 2017, addressing the obligations of carriers to assist with recovery from addiction. It also placed restrictions on prescribing opiates and other Schedule II drugs on doctors. I'm going to go through, really just kind of summarize briefly some of the key points of this legislation. If providers are only permitted to prescribe 5 days worth of medication for acute pain patients. It's not chronic pain, it's acute pain. Medication prescribed must be the lowest effective dose of immediate release opiates. Jeff touched on what time release was before. Immediate release would be Percocets, Vicodins, wherein the drug is immediately released into your system and is not released over the course of a day, for instance. That keeps, so 5 days of medication keeps providers from prescribing people 30 days worth of medication, obviously, which is really what used to happen. You'd go for some kind of injury, no matter whether it's a sprained ankle or a herniated disc, and a doctor might give you a script for 50 pills. That's no longer the practice in New Jersey, or should not be the practice. The second thing is providers, prior to issuing the initial prescription for either acute or chronic pain, they must document a thorough medical history, including a substance abuse history. Seems like a no-brainer, but this requires them to document this history in their file. I don't think that's probably been the practice of a lot of the doctors in the past. They likely didn't want to get into that. They have to conduct a physical examination, and they have to develop a plan of treatment with the attention specifically focused on the cause of the pain. And then again, review the prescription monitoring program. Prior to the first and the third prescriptions, the doctor must discuss the risks associated with the drug. So before they give them the drug initially, and if they go back for a third prescription, they have to discuss the fact that the drugs are highly addictive. They have to educate the patient on it. This is something that they'd never had to do before. And they also have to document their file. So if you ever request a doctor's file, they need to have notes in their file regarding this discussion. If they haven't done that, then you aren't sure whether or not they actually had this discussion with the petitioner. 4, doctors must enter into a pain management agreement with the patient upon issuing the third prescription. This is a contract. The patient has to sign it, the doctor has to sign it, and it lays out to the patient their rights, the doctor's rights, and how they need to move forward with the treatment under pain management. Also included in this is drug screenings, and more often than not, doctors, pain management doctors, will do a drug screening before they write the third prescription. If a petitioner or a patient comes up positive for other opiates or illicit drugs, they won't write the scripts. And or if the person has been on a pain management regimen at that point, the doctors will start to wean them off of it, because They're concerned of someone overdosing and dying if they're combining multiple drugs, even alcohol. And lastly, with regard to the legislation, after 3 months, the provider has to do an assessment to determine if the patient has developed a dependence on the drug. This assessment needs to be done every 3 months moving forward from that point to determine if a patient has developed an addiction problem. So since this legislation has been enacted early last year, one of the problems or issues that's developed as a result is patients are getting letters from doctors telling them that they can no longer treat them. And it's because of the rigorous requirements of this legislation on doctors. They're finding it hard to keep up with the requirements and the visits that they have to see the patient for. And therefore, they're kicking them off their practice. And that sometimes leaves us with a patient who needs to find a new doctor to continue their pain management regimen. Another issue that arises for us in New Jersey is a doctor is prescribing somebody, a petitioner, opiates, and it comes to light that they have a history of abuse. Sometimes the doctor will not change the regimen that he has them on. And what we can do in New Jersey and have done is at that point, you can get a second opinion and stop the treatment if provided your second opinion doctor says he would not continue the regimen of pain management. Counsel for petitioner will file a motion for medical and temporary benefits, and you go to court on it. More often than not, the judges are not going to order you to continue providing opiate pain medications to someone who has a history of abuse. They're concerned that the person could overdose and die, and they don't want to be a part of that. So quickly, just an overview about what I just talked about. First, you have the physician panel. You want to ensure the doctors you're using on your panel are conservative doctors and are good doctors. You don't want to use bad doctors. You don't want to get a bad result. You want to monitor the drug prescription monitoring program, and you should insist network providers act in compliance with the law. If you find you're using a doctor that's not acting in compliance with the law, that doctor is in violation of the law, could potentially be open to some kind of legal repercussions. So that's it for Jersey.
So in Delaware, we're basically at the extreme polar opposite of New Jersey when it comes to employer management of treatment. So we can control no treatment. The claimant can treat wherever they want to treat from day one of an injury. There's no legal significance to MMI that would stop treatment. So you have two options. One is utilization review. One is getting a defense medical report, an expert report that says that medications are no longer causally related. Those are your two options. It's very difficult to stop medical in Delaware. And you have to be creative in how you frame your arguments and your cases to try to do so. One thing that's been very helpful for us is the Center for Disease Control produced a comprehensive report on the effectiveness of opiates for treating chronic pain. So the reason their results were so useful to us, and first of all, the results are that they found there was no long-term benefit to using opioids for chronic pain, and the harms were far greater than any potential benefit. So everyone agreed that we need to stop abuse, we need to stop misuse, we need to stop improper prescription of opiates. However, what this study found is really that even when the protocols that are in place are followed in prescribing the drugs, and the patient uses the drugs as the doctor intended, there still is no legitimate benefit medically for chronic pain. End of life situation, sure. Initial stage after a traumatic injury, a motorcycle accident, something like that, yes, but not for long-term chronic pain. So what we'll do is essentially use this as our standard of care. They set forth specific recommendations, very detailed, there was a dozen or so, on how they should be used and what the physicians need to be doing. Interestingly, which I didn't realize until we started putting this presentation together, the laws in New Jersey, as John just laid out, essentially codify what the CDC put in their report as to how doctors should handle prescriptions. So I found that very interesting and good for New Jersey on adopting it. But what we'll basically do is say, look, Dr. So-and-so, are you familiar with the report? Oftentimes people that are supposedly addiction specialists, pain management physicians, don't know this report, which to me is egregious, but it happens. And then if they're not following the steps, well, then you can really argue that they have a lack of credibility. So that's how we've been using this. Delaware is also proposing some additional legislation. One idea is a stewardship program. This essentially is going to create a state fund of money. They're going to tax the manufacturers and prescribers for making the drugs available, for prescribing them. And there are provisions so that they don't just raise the price on the patient getting the drugs. But this tax would then go into a fund that the state would administer to deal with additional needs for treatment, rehab, and naloxone shots. So it has not passed, but those are some of the things that are being talked about. Other states have implemented it fairly effectively. Now, Delaware is actually really being hit hard in the last year or so. Overdose deaths are up 71%. So that was the highest of any state during that period, and that came from the CDC also, who's been monitoring the situation. So why that is happening, it's unclear, but there's some general ideas you can probably use to figure out what's going on. And as far as nationwide, the U.S. is 5% of the world's population. We get 80% of the prescription opiates. So that just tells you how prevalent this really is, and that it's not prevalent everywhere. Now, Delaware is a little unique in terms of how it sets up its litigation structure. The Industrial Accident Board, it's almost like a little trial before them. You're going to have an opportunity for an opening statement, closing argument, and when you present your whole case at once, so you really can frame your argument, hit the facts you want to hit during the trial to fit that argument, and then wrap it up for them at the end. And one of the things that we like to wrap up with in our cases that involve someone that's been prescribing opiates for a long time is that the board is in a unique position to make a difference in the opiate crisis, not only in the state of Delaware, but nationwide. I mean, they can stop doctors they feel are prescribing these inappropriately by saying it's not related. And you could call it guilting them, or maybe, but that is what I'm trying to do, because it's really in their hands. They just have to say, we're not going to accept this as a legitimate treatment. And much like the system that was set up in New Jersey that John talked about, there's a prescription monitoring program now in Delaware too. Obviously useful for physicians to check what someone else is getting. We know the obvious misuses when they're getting the same drug from two different doctors. But this can help our cases too, if you can find out that someone's been getting opiates for years before they even had your injury, something like that. And then there's an OSHA rule. This isn't specific to Delaware. It's pretty much specific nationwide, but it knocked out post-injury blanket drug testing, just saying anytime someone says an injury, we're going to have a drug test. So this was helpful at kind of weeding out people that were taking drugs already on the job. Now you got to be very careful, and you have to kind of tailor your program so that it's not a blanket test that could quiet people reporting legitimate injuries. That was the concern. This isn't a final ruling. It's being challenged, but something to think about. I'll turn it over to Luke in Pennsylvania.
All right, turning to Pennsylvania, as John was talking about in New Jersey, there's a panel involved. You have the 90-day panel period, as you know, where you have the period to have claimant treat with your providers, and that's like in Jersey. That's something you want to be very specific about, where you're careful about where the claimant's treating during that period. You don't want them to go to a provider that's going to overprescribe opioids and really start the trend with addiction and dependency right from the outset of a work injury, especially considering what diagnoses might be involved. We were talking a little bit before this presentation about some of the lesser diagnoses where you might see opioids come into play right off the bat. For example, a sprained ankle. You don't want your panel provider to be prescribing opioids at the onset of a claim. After that, as you know, the claimant can treat wherever, and if they're represented, that can be sort of a scary proposition depending on where they might end up and how that particular provider treats, especially if it's a pain management doctor. So talking about some of the tools that you have available in Pennsylvania, as you probably know, there's the utilization review process, similar to what they have in Delaware. It allows an employer to challenge treatment to determine whether it is reasonable and necessary. You use the utilization review request to initiate the process. That's something that you can do via WICAS. You can either have your counsel involved and assist you with that, or is that something you can do yourself as a carrier? When you're setting up the request, there's a screen in WICAS where you can search out the particular provider. It's pretty easy. It's almost like Google. You find them, their address, you put them in, you put the exact treatment you want reviewed. Normally, I recommend you do any and all and maybe specify some of the things that you have concerns with. And you can also delineate the time frame that you're looking at. In most cases, we're looking at a prospective review, looking at all treatment into the future, which is what you want to do. You also have the opportunity to challenge specific bills that must be filed within 30 days of receipt. So it's always a good idea if you want to wrap in a bill. When it comes down the line, you receive the bill, then you can file the utilization review off the bill, and then at that point, you don't have to treat while you don't have to pay for the treatment while the utilization review is pending. So what happens during the utilization review process? There's a utilization review organization that's going to gather all the medical records. There's going to be a particular provider within the same specialty of the provider that you're reviewing that's going to look over the treatment and render a report called the utilization review determination. And that provider who's reviewing the treatment of the provider under review is going to break down all of the different treatment modalities that are involved. You can see different prescriptions. It'll be prescription by prescription. If there's office visits, if there's urine drug screens, everything will be specifically laid out. From there, they're going to issue a report that discusses the background of that treatment, what's accepted, what the standards are, and what their determination is, specifically whether it's reasonable or whether it's reasonable and necessary. If it is reasonable and necessary, you have to continue to pay absent filing a petition to review. But if not, you can stop at that point. And what we usually see, some parties upset with the result of the utilization review. If it's unreasonable and necessary, you see the claimant's going to file a petition to review. If it's reasonable and necessary and the employer is not happy, then we have the option of filing a petition to review. So what happens from there? After the petition to review is filed, the utilization review is going to go to a workers' compensation judge where each party has the opportunity to present their own expert. And from there, the judge is going to make a determination whether the treatment's reasonable and necessary. I think one thing that's always important to discuss with the Pennsylvania utilization review process is it's provider specific. So in the opioid realm, you might have a particular provider who's prescribing some pretty hefty opioids, and you want to essentially stop that treatment altogether. Well, unfortunately, since it is provider specific, you're only going to prevent that particular provider from prescribing those medications in the future if you prevail. So what we see is when claimants are represented, that their attorney will refer them to a new provider, and you might see the same treatment continue. But one of the benefits of the utilization review process is it can push a claimant away from a particular problematic provider who may be overprescribing. I've noticed in certain cases, you also have the opportunity to discuss maybe a future resolution of the case with opposing counsel. And maybe when you make the move to a new provider, you can look for a more conservative pain management doctor who can start the weaning process that will make it possible for you to get an affordable MSA and close out some of these difficult opioid claims. So just quickly to touch on something from the legislative end of things in Pennsylvania, there's a particularly important bill out right now. It's Senate Bill 936, and this is a legislative effort to curb opioid abuse in Pennsylvania and general drug abuse or prescription abuse in Pennsylvania. And the way it's going to work is they're going to try to implement a drug formulary program. And what that is designed to do is essentially set out what treatments are going to be reasonable and necessary, determining on what type of diagnoses we're looking at. It'll cut back on extended durations of opioids, for example, in a case where it doesn't make sense based on the diagnoses that you're looking at. It'll prevent someone from potentially prescribing opioids and some of those lesser diagnoses that we're discussing, like an ankle sprain, strain. It's just going to essentially put an end to that. Let's see. So if drugs are outside the formulary, they'll be per se unreasonable and necessary. The current status of the bill is it has passed in the PA Senate and it's currently pending in the House. It's a pretty close vote now, so I'd like to urge you as employers to go out there and contact your lawmakers and show support and see what you can do, get involved in your chambers, whatever groups that you are involved in right now, to contact your lobbyists and see what can be done in order to help push Senate Bill 936 through in Pennsylvania.
That's great. I know Texas has a formulary, I read, and it's drastically reduced the amount of drugs that doctors are prescribing in the state. So that would be great if you guys get that bill.
Yeah, it makes it awfully inconvenient, I guess, if you're trying to prescribe.
I think that's it for us. Thanks everybody for tuning in. And if you have any questions, you can contact any one of us here with regard to Delaware, New Jersey, or Pennsylvania. And thanks for tuning in.
Thanks, everyone.